what happens if you don't have an estate plan in place? And, oftentimes people have the mistaken belief that just everything's going to go to the spouse. And that's not true. So certainly assets that are jointly held with someone else, whether that be a spouse or whether that be a child or someone else who's important to you in your life, when there is a right of survivorship in that ownership scenario, then yes, that asset will go to that individual upon your death. Another scenario in which assets will pass to a named beneficiary would be something like a retirement plan, life insurance policies. When you have actually named specific people as beneficiaries, then those individuals will take that asset upon your passing, and it will not get affected by what I'm now going to talk about, which is the intestate laws here in Massachusetts. So the intestate laws come into play when someone has passed away without a will, and they own assets in just their own name at the time of their death. So no joint ownership, no right of survivorship, and no named beneficiaries. And so we often see this with bank accounts, investment accounts, real estate, all types of assets may be caught up in this. And the intestate laws in Massachusetts are going to dictate who ends up having priority in terms of taking, should you pass away without the will, which would provide instruction. And again, most people think, well, if I pass away, everything's just going to go to my spouse. And what the intestate laws actually say is we kind of look at what I call the airplane. We begin to look at who has priority. And certainly a spouse always has priority, but if there are children, let's say, from a previous marriage, those children also take under the intestate laws. So the spouse does not take 100% of what might be left. The children, if they're the decedent's children, the person who passed away, if it is their children and not a child that they share with their current spouse, those children will take a share as well. If there are no children, but an individual passes away with a spouse, but their parents are alive, then the parents, in some instances, may step forward and take a portion of the estate. So very critical that you understand that if you pass away without having clarity, without having an estate plan in place and having a will at the very least, and or a trust, then the intestate laws will come into play, and you may not be leaving everything to the intended people, a spouse, that type of thing that you might have thought you otherwise would be. So very, very important that you do take a look at an estate plan, get something in place so that there is clarity about how things are going to pass. I actually had a situation many years ago in which an individual, it was a younger couple in their 50s. The husband died rather suddenly. They never had children. He had been estranged for probably close to 30 years from his father. His mother and father were still alive. The mother had predeceased him and had actually left her son an inheritance. And all these assets were in the son's name alone because the mother had died fairly recently before he did, and he never had a chance to be able to get them into a co-ownership situation with his spouse. He died. He did not have a will in place. And what ended up happening is his spouse only ended up taking a portion of the estate that had been in his name alone. And his estranged father, who he hadn't seen again for close to 30 years, ended up taking a portion of the estate as well. So a very unintended consequence with that type of a scenario.